We'll hear from you when you're ready. Before you start, and you may already understand, they may already know this, but just to make sure we're all operating on the same page, each side has 15 minutes total. Since you're the appellant, you can reserve some portion, a smaller portion of your time for rebuttal. You could go 10 minutes now and reserve 5, or 11 and 4.
Just don't get a rebuttal after I spend
They don't get, they have their 15 minutes after you do your first part. But that's it. Once they get up and use their time, they're done. But then if you reserve some time for rebuttal, then you get to get back up after they've made their argument.
Okay.
So do you want to reserve any time for rebuttal?
Yeah, say about 5 minutes real, I guess.
5 minutes will be fine. So you have 10 minutes now, and then you'll have 5 minutes after they do their argument. She'll take care of it over there.
Okay. Yeah, this all started back in 2020. February, a guy I know broke into my house when I was asleep and come in there. He always knew I had cash on me because I used to do construction. But he broke into my house and come in and hit me with a ball bat. That was the 28th of February. So, you know, after he done got my money and left, I stayed in there until my ex-wife brought my daughter over, you know, for me to visit with her and seen what had happened, you know, and I was sent to Erlanger March 1st. Well, when I went March 1st, I had to have a surgery done because it fractured my skull, and there was some bleeding in there. And Dr. Patel, the neurosurgeon, and Dr. Thirston, the plastic surgeon, he's the one that did the closure and all that. But anyway, I stayed in there till from March 1st to the 16th of March. And I was sent home, and I was stayed at home for 8 days. And my head was swollen over here on the left side where all this happened. I mean, Vandergriff actually had to go through another big surgery. And November 29th, 21, and but during when my head was swollen and my vision was blurry in my left eye, so my neighbor called the ambulance for me to go back to, you know, was sent back to Erlanger, and when I got into Erlanger, you know, it was swollen. I had quite a bit swollen, and I couldn't see seemed like my eye was not getting any better at all either. So they set me up for a surgery. They said that I had cellulitis of my scalp, which is, you know, it's soft tissue infection. All the records, I guess y'all got all those records, but
yes, sir, we do.
But the records from, it was 3 days I was there. While I was out, I went in there on March 24th, and I was dismissed the 27th. But it goes through the records, and it states that I had a soft tissue infection, no bone involvement documented. And I put all that in my original brief that I filed, because I filed a reply brief. And but I went through all the records that's in there, which you can see, but I was released on March 27th. So, you know, it was at that point, you know, I had soft tissue infection, no bone involvement documented. So I had routine visits I started going to at Erlanger Plastics Clinic. And Thirston worked there. I think he was the director of it at that time. Todd Thirston, the plastic surgeon. And I started going there the 30th of March. And which I've got in my complaint, 4/6, April 6th, I went into my routine visit, and I had staples in here and seizures in here, and I told them that I actually said it, and it's in my complaint, is that I expressed concern about the pus drainage that was coming out of my head, So they didn't remove the staples yet, but they removed the seizure part of it. It was right in here. I had them still right here. And it's, and of course, I told them about the pus drainage. And when I told them that, and in the record they got, and it's wrote in my 27 of my complaint, that I had told them about the drainage, and they said that they would keep an eye on it. And, because I had to go back every week to visits, and they took the seizures part of it out, except for right here, and they said they was going to leave those in there. They didn't take those out because they had they called it an overlying area of concern. And see, I said express concern. And the way the judge talked about this, he's like that I had reasonable suspicion that something was going on wrong. I mean, I didn't have reasonable suspicion. I mean, anybody, if you got pus coming out of old surgery wound, that's going to speak. You're going to be interested in that. Anybody would. That's a pretty simple question, but I told them about that, and they said they'd keep an eye on it, and they put me on Bactrim antibiotics. They gave it to me that day, so I went to come back on the 4/13, April 13th visit, and my record says that I had fibrous pudent drainage, which is, white milky kind of, it's serious, very serious, kind of drainage from it. It means infection, so, they gave me they said I was still on antibiotics, and they did tell me in 4/6 appointment that if the drainage got worse, that I might require another surgery. So, but I went on through 4/13. They give me a refill of the Bactrim. It's two different antibiotics together. It's strong Bactrim, but what happened next is,
Mr. Vandergriff, in your brief, you
Have a question over here.
you said the trial judge got it wrong in terms of saying that you should have been aware essentially as of April. And here I'm not talking about the stuff that happened in May or the stuff that happened in June. I'm talking about the medical procedures that were in March and April. What did you learn in May? Because if I'm following your brief correctly, you're saying around May 8th is really the day that you should. Yeah. What did you learn on May 8th that you think that's the right date instead of the August 6th date?
Because like I stated, the hospital stay that I stated from March 24th, March 27th, when I got out, the paperwork, it's in there. It shows several pages. I've got it in my brief, which it points out the pages, but it says soft tissue infection, no bone involvement documented. So, I went through that time from March the 26th. That was the last day that I had my white blood count, or CBC, white blood count done, that was right before I got out on 27th, see? And that's the last day it was done. So, if somebody's, it's in the standard of care, especially if you're going to, you're having, pus drainage out of a surgery one, and you keep having the drainage. In the standard of care, it would be to make the next move. Well, let's check into this, see what's going on here. But no, they didn't. They just let me go. I kept going into my routine visits. And the next one was 4/20, which I still had the drainage going on. And but they had took me off the antibiotics at that time. And, I ran out, so they didn't give me any more antibiotics. But I went back on May 4th, was my next time to go back. And I still had the drainage going on. And, all this has put my left eye completely out. I mean, when I went in and my vision was not right in my left eye, that from that point, it just, just continued to just get worse. And by the time, 4:13, I told them I couldn't see nothing. They asked me if I could see light out of it or anything. And I thought it was just black. And that's how it still is.
Mr. Vandergriff, you had a third surgery performed in May, is that right?
Yeah, I know I'm slow, but I'm getting around to it. But what it was on May the 4th, when I went in there, I told them again about the drainage, and there was a place on my head right here where, because I couldn't see that good, I was having to get up in the mirror, but my skull was showing right here. And Dr. Thirston talked to me about it, the plastic surgeon, and he told me that we needed to get together, and he was going to set me up a surgery, and he was going to, do just plastic surgery over it and cover it up, with, just minor skin surgery. But, so he told me that was on a Monday, 5/4. So he had set it up. I got it where he ordered the surgery on 5/4. Now he called it osteomyelitis, which that is bone infection. So through that period from 3/26 to 5/8, I never had a CBC done. Now 5/8 I did. Now on March 26th, my white blood count was 11.6, and it had escalated at 5/8. I mean May 8th. I hate saying that, but May 8th it was 14.6, which it's all in the records, and I've got other records right here that shows when all my blood counts was done and everything. But it actually shows, and I can provide them with y'all, before I leave. Or I don't know if you make a decision right away or what, but anyway. But when he did the surgery, what he got in there and done, I was not aware of really, and I got they got what they call an after visit summary. And the way I look at it, I mean, a lot of hospitals can get away from putting little things in there, that's in the actual record, But it said that I had debridement, which is clean out in that third surgery. Clean out, the infection and, cover the spot. But it did say that I had osteomyelitis of the skull, which is my skull bone. And what he did is he took on the surgery order, which is in there, he took a drill and drilled my bone out right here. I've got a big dent in my head with Vandergriff. They had to put, I had this whole infection from 5/8 until 11/29/21 when I went to Vandergriff and had a real neurosurgeon. This Thirston guy is just a plastic surgeon. He does not have the right to do a neurosurgery. That's craniectomy, what that's called. That's cutting my bone out of my skull, which is, it's brain surgery. That's what it is, brain surgery. And you had, I guess they tried to, because he was the director of that department, the plastic surgery department, that they seen what they'd done, and they was just trying. He did the surgery, and it was just the outpatient surgery. I went in, which it did take 5 hours or so, but he went in, and let me out that day. Now the standard of care, if somebody does a craniectomy to remove infected skull bone, That's CPT code 61501, neurosurgery code. So, you know, that's,
Mr. Vandergriff, we've given you some extra time, but you've used your time. We gave you some extra time.
I can finish up in a few minutes. Okay.
Yes, you still have your 5 minutes you reserved for rebuttal after they finish.
Thank you, Your Honor.
Thank you. We'll hear from the appellee.
Good morning, Your Honors. Josh Powers, counsel, Erlanger Hospital, Aaron Wells, Thirston. We were planning on splitting roughly like 8 minutes.
8 minutes for you and then 7 minutes here.
Yes.
Okay. That'll be fine.
Thank you, Your Honor. The issue before the court today is whether the statute and Judge Hollingsworth's rule statute. The starting point is looking at the Health Care Liability Act, which requires HIPAA authorization, a valid HIPAA authorization, so that co-defendant Erlanger Thurston, Judge Hollingsworth rightly found that the HIPAA authorization did not give Erlanger the right to collect records. The effect of that is.
Let me ask you about that. Didn't the court say documents submitted by Mr. Vandergriff only lists the defendants? It does not provide authorization for the defendants to obtain medical records from any other providers.
Well, it's that Dr. Thirston is not an employee of Erlanger.
Well,
Therefore, the authorization that Erlanger had was him not give Erlanger the right. If I sent that to Dr. Thirston, because it did not identify, there was nothing on the authorization, just a form. It did not give Erlanger the right.
well, I mean, the trial court found, though, only lists the defendants. And that's what the trial court found. It says that it completely failed to provide the authorization information to which the defendants are entitled under the statute.
I think what the court
It says it doesn't provide any authorization for the defendants to obtain medical records from any other providers.
And that was accurate. We were not entitled to give from any other providers, but I think what the court was saying is that each defendant got a HIPAA authorization, but it was. You put a copy of it in our brief. It's when you send a HIPAA authorization, if I want to send one to any other provider, whether they're a co-defendant, not a co-defendant, the authorization needs to identify, I'm allowing you to get records from anybody, or from Dr. X, or from Hartbridge Hospital, or from Fort Sam.
Is that what's required?
Yes.
Or is it by the statute, or just has to be able to get records from any other defendants to be named, I guess?
I think it's
Just it says any provider?
I think the way the statute is written is that I have, as a pre-suit notice recipient, I must be able to records from the other pre-suit notice that are listed. There were 4 different pre-suit notice recipients. We had that in our footnote 4, the 4 that were listed. Authorization did not allow Dr. Thirston to, if Dr. Thirston, Erlanger, ineffectual, it's blank. It doesn't say anything about anything. No authorization by Vandergriff to obtain records from anyone.
Or is it accurate then to say that it's your position that that the authorization is simply not HIPAA compliant, even though the trial court said the reason was that the document submitted by Mr. Vandergriff only lists the defendants. It does not provide authorization for the defendants to obtain medical records from any other providers. Is the trial court correct that for it to be HIPAA compliant, it had to provide that the named defendants could obtain medical records from any other providers?
I think that technically the trial court's, that statement in that order is not the law. I think the law is
I think that's probably correct.
The pre-suit notice recipients must be able to obtain records from the other, not from the world, but
Yeah.
from the other pre-suit notice recipients. And we think it's clearly our position that the authorization issue in this case did not meet that. I mean, it did not give Erlanger the right to obtain records from Dr. Thirston.
But not for the reason the trial court gave.
Correct.
All right,
Yes.
go ahead.
And so then the question is if the plaintiff is not entitled to this additional 120 days, therefore the statute of limitations is old traditional year, 185 days, 65 days. Next question is, cause of action accrue? I think that the facts in the record clearly show that the cause of action accrue no later than 6, 20. Question of when does a cause of action accrue? Cause of action in the healthcare liability action is governed by the discovery rule. Or to run. A reasonable person knew or should have known the cause of action. Cited case law that says that, I think this is from the Jackson case, so it says either actual knowledge, so you don't have to have actual knowledge. I think Judge Houston, this may have been what you were the Jackson case goes on to say, nor diagnosis of the injury by another medical professional. That's not required to initiate the running of a statute.
Counsel, does impairment play in at all to the application of the discovery rule? And Mr. Vandergriff is essentially saying I had a serious brain injury. I was extremely confused. He's got a serious infection going on in his skull here. Does that play into how we look at the discovery rule, how we look at notice? And he's essentially saying I was pretty confused in March and April.
But there was proof in the record. No proof in the record to that. If there was proof in the record from a provider that said, there was an expert opinion, because that's, I think that's, none of us are physicians. None of us are going to know is somebody competent unless it's just, on its face, is somebody competent or not, and there's just no proof in the record to that effect. Once the lawsuit was filed, we obviously had numerous conversations with Mr. Vandergriff, and while, he certainly not an attorney, decent sense kind of what was going on. I think it's interesting, Your Honor, this is not the first time that Mr. Vandergriff has appeared in this court pro se. Cited a previous case of Vandergriff versus Park Ridge Hospital. It's a 482, 545. In that case, the court side was talking about pro se litigants. Part that's therefore, courts may not excuse pro se litigants from complying with the same substantive and procedural rules that represented parties. So I think there's got to be proof in the record of for that.
Counsel,
Not have
I have a question about a couple of the claims that Mr. Vandergriff is making. One is related to, and I know you're representing different clients here, but I think you're both potentially implicated with regard to this question in terms of your clients. May and June.
Hey, let's pause a second here, kind of stop the clock. Yes. Yes. Okay.
I'm sorry.
Sorry.
That's the first time anybody's ever said that I can't
Yes.
be heard.
Let it go.
Let me hit the. Okay, is that better? Okay. Yeah, no one has, my wife certainly has not accused me of that.
Now you can tell her.
May and June, there are allegations related to medical malpractice and actions with May and June. How can those be outside a one-year statute of limitations for an action filed April 14th when the underlying action occurred in either May, or I think Erlanger's is June, and maybe Dr. Thirston's is the surgery in May. I may have those dates backwards, but how can a one-year statute of limitations have run for an underlying medical malpractice event that occurred within the one-year time period?
Well, so I think that the question is when did the statute of limitations start to run? And the way I've interpreted the lawsuit is that at this first surgery that was done in March, that's where the negligence occurred during that original surgery that Dr. Thirston and Dr. Patel, because that's the only surgery that Dr. Patel was participating in.
But aren't there allegations as to negligence essentially with each surgery? And maybe Mr. Vandergriff's wrong. Maybe there was no negligence with the third surgery. Maybe there was no negligence in the treatment in June. But isn't he making a claim that there was negligence with the third surgery and negligence with the medical treatment he received in June?
I have always understood that the claim arises out of the initial surgery, because I think what you get to, and we cited the kind of the continuing medical doctrine that that this court abolished a number of years ago, the continuing treatment doctrine, and that all of this arose because everything. Why did Mr. Vandergriff need additional surgery? Because he had an infection. And the infection clearly arose prior to the second surgery and the third surgery. So all of this is it's simply treating an infection. It's not as if there was another tort that occurred. It's just the treatment of the sequelae of this original surgery. Thank you, Your Honors.
We're here from counsel. No, he took, no, it's not quite your time yet. He took 8 minutes and he gets 7 to add up to their 15, but you'll have your chance when he finishes. Yes, sir.
Good morning, Your Honors. May it please the court. My name is Aaron Wells, from the Chattanooga Bar. I represent Dr. Todd Thirston in this case. I'm not going to try to retread too much ground that Mr. Powers covered, but Judge Swiney, there was one question of yours that I wanted to go back to about the trial court's order with respect to the notice defendants. I think what the trial court was referring to there was that Mr. Vandergriff provided a separate list of providers that he sent pre-suit notice to that was separate from his HIPAA authorization. So I believe that may be what the trial court was referring to in its order. I would also like to touch on accrual of these claims, and this sort of goes back to your question that you just asked, Judge Usman. I believe by April 6 of 2020, Mr. Vandergriff was on notice of issues with his head and this infection that would lead a reasonable person to believe that something may be going wrong. And that is, by March 24th of 2020, he had noticed swelling on the left side of his head, difficulty with his vision. That led him to go back to the hospital on that date. And at that time, according to his complaint, on page 4 of his complaint, he learned that he had a severe infection in his skull. After that, the plaintiff underwent this second surgery by Dr. Patel and Dr. Thirston, and then he was discharged and began treating at Erlanger Plastics between March 24 and April 6 of 2020. That's when on April 6 he comes back to the hospital and says, I have this pus draining out of my head, and it's concerning to me. It's at that time that we submit to the court that a reasonable person would be on notice that he may have a cause of action. And Judge Usman, going back to your question about the May 8th, 2020 procedure that Dr. Thirston performed, and why that doesn't not extend, but why isn't that a separate claim for negligence? And I would answer that by saying, echoing what Mr. Powers said, the injuries that the plaintiff alleges are all traced back to the initial procedure in March. That is his infection, his loss of vision in his eyes, headaches, memory loss, all of those things Mr. Vandergriff alleges are traced back to that first procedure in March.
So if there's negligence in a later surgery, and I'm not saying there was, if there's negligence in a later surgery, no matter how bad that negligence is in that surgery, as long as you say, well, he had to have the second surgery because of what happened in the first one over here. I mean, is that what you're saying the case law says?
That is not what I'm saying, Your Honor.
Thank you, I'm glad.
That is not what I'm saying. What I'm saying is that The plaintiff doesn't allege any new injuries that arise out of this.
Does he allege that surgery was performed negligently?
He does not. My understanding of his allegations with respect to that surgery is that Dr. Thirston was not qualified to perform that procedure, and that's the violation of the standard of care. There's no separate or new injury alleged out of that surgery.
Counsel, isn't his claim that the third surgery was designed to ameliorate the problems that were caused by the first and second surgery? So if the third surgery is negligently performed, he's suffering because he wasn't appropriately treated in the third surgery, that his pain and suffering would have come to an end if the doctor had done it the right way. Isn't that a negligence claim with regard to the third surgery?
I believe it very well could be, but I don't know that that evidence is in the record. And I don't know that that's the cause of action that Mr. Vandergriff pled.
He does say he had additional headaches caused by the third surgery, right? That he had additional headaches that were caused, then he ties the claim, not proof, right? But he claims that additional headaches were caused by the third surgery.
He does.
Okay.
He also claims headaches in connection with the first procedure as well. And all of this is notwithstanding the fact that Mr. Vandergriff still did not send a HIPAA-compliant authorization. So take it as true. Dr. Thirston was negligent in May of 2020. Take that as true. Mr. Vandergriff still did not provide Dr. Thirston with a HIPAA-compliant authorization, which still supports the dismissal of the plaintiff's lawsuit.
He doesn't need an extension, though, right, for the third surgery if it's within the 1 year time. Is the HIPAA compliant aspect here coming into play beyond the 120-day extension in this case?
Well, I think the HIPAA compliant or the HIPAA issue comes into play regardless, because the statute says that in order, as a prerequisite to filing these lawsuits, is they've got to have pre-suit notice, and one of the things that has to be included in that pre-suit notice is a HIPAA-compliant authorization that enables Dr. Thirston and the other providers to go out and get early access to Mr. Vandergriff's medical records.
From each other. I'm sorry. From each other.
From each other, correct.
Okay, I'm sorry.
The distinction could be a dismissal with prejudice versus a dismissal without prejudice.
And the trial court, in terms of addressing the HIPAA issue, only addressed the 120-day extension, right? There's not a separate ruling that the case is dismissed based upon failure to, it's just in connection with 120 days.
I believe that's fair, Your Honor. I believe that's fair. Your Honor, that's all I have. I'd be happy to answer any questions the court may have, but otherwise I'd just respectfully ask that the court uphold the trial court's order.
All right, thank you.
Thank you, Your Honor.
Thank you. Mr. Vandergriff, you have your 5 minutes now, sir.
Yeah, but the main thing here is what I'm saying is when he, about Thurston, the plastic surgeon, when he went in and done a craniectomy on me, he was not supposed to do that, and that's neurosurgery, supposed to do that. And yes, I did have injuries from it, if you call having osteomyelitis for a whole nother year and 6 months till I made it up to Vanderbilt. That they treated me right. I stayed up there for 8 weeks in hospital, going through antibiotic treatment and the major surgery I had. I mean, I've got all the records. I mean, I can leave them here, or if it gets sent back, if it gets sent back to court, I can put all. See, that actually the 18th when I went to court, April 18th when I went to court, I was not in a right frame of mind at all from having that surgery. It was November 29th, 21. A friend of mine wanted me, I wasn't driving or nothing, he wanted me to drive his truck from Brainerd Road down, I don't know if y'all know where that's at, from Brainerd Road to his house, which ain't far. And and this stuff made me have seizures with an infection going on all the time in my head. I finally got rid of the infection because a neurosurgeon and plastic surgeon, they work in conjunction together. Plastic surgeon does the closure stuff, anything that's to do with, and they had to drill more of my skull out, Vanderbilt. And the part that they're talking about the 120 days, as far as as what Thurston did, I don't need
Mr.
no...
Vandergriff, pull the microphone a little bit, yeah, so we get you.
Yeah, I don't need no 120 days, because I filed it on April 14th, and what was done to me was done on May 8th, which I was, well within the statute of limitations of what was done. But see, during this soft tissue infection, with Erlanger in mind here, is that I had soft tissue infection during that second surgery I had. Soft tissue infection, no bone involvement documented. That's their actual words. That's what they say in there, and I've got all listed in my my main brief and reply brief. I talk about it, but I've got all my important medical records and all that in there. But as far as that 120 thing, 120 days, I sent mine in, and the reason I didn't write their names on it is because if I would have wrote their names on it, then the next come back would be, well, you filled it in where I couldn't write my name in it. You know what I'm saying? So it kind of confused me. I mean, I was out of my mind. I had infection going on in my head, and I'm just now, this is a really good friend of mine. He's took care of me, and he can answer the question. I was out of my mind. I could barely even I wrote my own complaint because I went to lawyers, and I was stuttering and going on so bad that, they couldn't understand me. And I was trying to get, my friend Danny here for me to tell it to him, and he just couldn't grasp what I was, as far as reading and stuff, I could do that. But as far as me explaining stuff to people, I was just, and couldn't even say hardly anything. I felt awful. I didn't even know if I was ever going to come out of it. But since I have had this surgery at Vanderbilt, it has really straightened me. I've improved every day ever since that. But going through a whole year of, and one thing is now you see me sitting here writing, I have extreme memory loss. I write stuff down that I do every day, and that way that I look at that the next day and see and understand what I did the day before. That's how it is, and it's still like that. It's just that I've read through all this stuff enough that I do have my dates and everything, but I have from Vanderbilt right here, they give me a paper and said amputation was done on the bone in my head. And he also, and he didn't put this in his record, he put mesh over my head right here. Now, I don't know if y'all did you see the records with the screw showing out of my head? Have y'all seen that?
We've seen the records now.
Yeah, because, that's why, after that May 8th surgery, come August, I went to my regular doctor, and he noticed, he could see down in there, and he took a flashlight and said, it looks like I can see titanium plate and screw down in your head. So it kind of freaked me out, I didn't know what was, but Patel, he's in this suit, but he actually is a neurosurgeon. I think he would have done right on going back to another surgery again, but it was Thirston. He told me that Thurston's got to be in it, the plastic surgeon, for closure. And I was like, no, I'm not going to do it. And
Mr. Vandergriff, you've used your time.
Okay.
The way it works from here is we'll take the case under advisement, and then we'll issue a written decision, and it'll be sent to you and to opposing counsel over here at the same time. So you'll both be notified at the same time what our decision is, and it'll take us a while to do that. It won't be
Can I say one thing now?
Quickly.
I just want to be able to take it back to court where I can present it, where I can actually talk and know what's going on without having it written on my hand and everything else, something where I can have, and I have been disabled since all this. I was disabled when I wrote my complaint. I'm still disabled now. you know, and I mean, I'd let you feel that dent in my head. I mean, I come over and show it to you if you want me to.
No. The way the rules work, what we're required to do is we can only look at what was in the trial court, like you mentioned, the record. The records come up to us, and that's what we have to look at. We don't take new testimony from witnesses, or we don't receive new documents, that kind of thing. We have to base our decision upon what's in the record that the trial court had.
I just would like to have it sent back to court. That way I can put all my stuff that came from Vanderbilt in the record, and I've got it. See,
Yes,
I got it. Yeah.
All right.
But thank y'all, Your Honor.
Court thanks both sides. We appreciate your arguments this morning and the briefs. Thank you. Recess court till this afternoon, please.
All rise.